practice group's going to lead off for a couple of minutes with describing the practice group.
Whatever it is, but don't let me drag it. I heard what I want.
I didn't bring a gavel.
Yeah.
Throwing things works.
All right, if we could go ahead and get seated so we can get started on time.
Huh? Are you?
Everything's fine.
Is it going to work? Yeah. All right. So what we talked about with the
We're on a tight schedule because of the luncheon, so
we're going to kind of kick things off and tell people to get set up, and then we can introduce ourselves or whatever.
Okay.
Good morning. Good morning. Good morning. Thank you. My name is Jack Park. I'm the chair of the Professional Responsibility Practice Group. The practice group looks at professional responsibility issues pertaining to legal education, issues pertaining to judicial selection methods, among other things. One of our goals is to offer programs that generate CLE credit, ethics CLE credit, and we've historically done that. In 2013, we did a standalone one-hour ethics program that was open to Federalist Society members. We tried to do that again in 2014, but it didn't work. We'll try to do it again in 2015. Watch for that. You know, we want to be of service to the members. If any of you are interested in the issues that we talk about, please don't hesitate to talk to me, and we'll be happy to try and find you something to do for the practice group. But thank you all for your consideration. I'd like to turn it over now to Judge Jerry Smith.
good morning and thank you for being here. Welcome to our session entitled The Dog Ate My Emails, Document Retention Policies, Litigation Holds, and Legal Ethics. I recall a million years ago when I was in antitrust practice with Fulbright and Jaworski in Houston, we used to pass along a story. This was back in, of course, the days of everything was hard copy and Xerox machines and all those ancient things. But the story was told from something that happened with another law firm and its in-house client, major antitrust case. There were some sensitive things going on within the company, and the general counsel put out the word to destroy, get rid of certain categories of documents, and then sure enough, a few months later, a suit was filed and a discovery demand made in-house for those categories of documents, and a young attorney within the department suddenly produced all these reams of hard copy documents, and the general counsel went into him and said, "Wait a minute, what's going on here? These are a big problem for us. I told you to throw all those documents away." And he said, "Well, I did, but I also followed the policy you gave us in my first week of orientation, which was to keep copies of everything." Well, of course, things have changed now, and there's no such thing as getting rid of copies in the electronic age. Once upon a time, corporations and government departments and other entities made their own decisions about how long to retain documents created or received in the course of business. Today, document retention policies can present difficult issues for the entities, for the lawyers, and for the courts that are called on to decide the consequences when documents are no longer available. Maybe we should put the word available in quotations. Particularly in the electronic age where computers die, people delete their emails, and backups are not always reliable, document retention can't be counted on. What are the attorney's obligations? That's why you're here. Should a lawyer bring suit bringing suit right to the other side and warn the entity not to engage in normal document destruction? Does the company being sued have to comply with that? These are some of the questions that our really fine panel will address. In-house lawyers face particular difficulties, as with the story that I gave you. Does the lawyer represent only the institution, or does the lawyer also have obligations to the employees? Should the lawyer advise the employees to censor themselves in emails sent via the employer's email system? Should employees be encouraged to communicate about work through their personal email instead? How does an in-house lawyer handle the conflicts between representing individuals who don't want to disclose discoverable emails for emails unrelated to ongoing litigation? Finally, the panel will discuss special obligations for counsel representing governmental entities. Government records have a unique status, and that will be addressed as well. We have a spectacular panel of attorneys who have been on the ground practicing in diverse areas dealing with what we'll be talking about, which is eDiscovery and document retention. I'll give you their brief but impressive resumes. Patrick Oud is a partner with the law firm of Shook, Hardy & Bacon and leads the firm's practice in e-compliance and digital investigations. Formerly, he was special counsel for electronic discovery in the Office of the General Counsel of the SEC. Jamie Brown is Global Discovery Counsel for UBS AG in New York. Formerly, she headed the eDiscovery program for the U.S. Commodity Futures Trading Commission and has private firm experience in complex commercial litigation. Dan Epstein is Executive Director of Cause of Action, a nonpartisan organization that uses public advocacy and legal reform tools to ensure greater transparency in government, to protect taxpayer interests, and to promote economic freedom. Jonathan Redgrave is a founding member of Redgrave, L.L.P. in Washington, a firm focusing exclusively on addressing complex legal challenges that arise at the intersection of law and technology, including eDiscovery and data privacy and security. Julie Reiser is a partner of Cohen, Milstein, Sellers & Toll and a member of the firm's Securities Fraud Investor Protection Practice Group. She focuses on enforcement of securities laws on behalf of sophisticated institutional investors. She was impressively on the legal team in the prominent case of Dukes versus Walmart, as well as several others. With that, we'll begin with Patrick Oud.
Thanks, Judge, and welcome everybody. This is going to be one of the few times that we ask you to get out your phones, get out your iPads, or get out your Blackberries if you're an old schooler like me. And because this is an interactive, engaging polling panel, and we're going to ask you questions for feedback based upon some hypotheticals that we put up. So you're back at law school, everybody. It's a Saturday. I'm sure you all wanted to be there. So we're going to jump in first really quickly. And just set up the problem here. Everybody wonders, is like, why do I have to save all of this stuff? There are some traditional drivers, right, that we're used to, like your business requirements. I have to save this to defend my patents. I have to save this financial information to ensure I can make my disclosures next quarter. But there are some nuanced stuff that non-lawyers might not be used to. Most of the people in this room, I'd imagine, have a really good understanding of what litigation holds are and what those obligations are when you're involved in litigation. Another sort of nuance that comes out of this too, if you are in a certain practice area, for example, if you're in financial services, what are your Dodd-Frank retention obligations that might be different than your litigation hold requirements? So all of these requirements really came out of kind of antiquated physical evidence retention requirement law. So if we go back in time, if you could imagine, I parked my car in my house, the car explodes, the house burns down, I charge General Motors, the manufacturer of the car, with some sort of problem that caused my whole house to burn down. The insurance pays it out. The insurance company fails to preserve the car, and lo and behold, 3 years later, we are involved in litigation and no one had a chance to look at that car. So fast forward to where we are now, we're dealing with the retention of electronic information, things that are a little bit different. So there is a nuanced approach that is required now based upon case law throughout the country, mostly in the Second Circuit, that we're seeing a process requirement to implement what's called a legal hold. That can be based on litigation, that can be based on an investigation, but the overall takeaway here is reasonable anticipation of litigation. So if you think you're about to get sued, you probably should issue a legal hold or start to retain evidence. So with that framework, we're going to set up our first hypothetical. So please get out your devices, and we're going to talk about spoliation. And what that is either the negligent or intentional destruction of evidence. So this whole preservation process that we're talking about, it keys off to avoid charges of spoliation. And the punishment for spoliation can oftentimes be as bad as a default judgment against you, an adverse inference that the evidence that should have been there is no longer there, but the jury is charged with an instruction that the evidence would have been unfavorable to your case. All bad stuff. So jumping into the hypothetical, there are two ways to do this. The first way is text message, which if you're an old schooler like me, that's the way to do stuff. Alternatively, you can go to the web page, which is PLLEV.com/eDiscovery. That's probably the easiest way to do it. I'm going to push that poll right now. And setting up the hypothetical here, Jenny Counsel from Supercon, big company, receives a report from Employee Relations that former employee Polly Plaintiff has called the 1-800-severance phone number 3 times and is threatening to sue on the basis that her termination was improper. Should you advise Jenny, as her lawyer, to issue a legal hold? And the answers are very small on the screen, but I will read them. If you're texting, the phone number you're texting to is 22333. That's the phone number you're texting to. And the message you're sending for the first answer will be, Polly is just another disgruntled employee. You don't have to do anything. So text 49103, or if you're using the web interface, you can just click on that answer. The next answer will be, if Polly made a preservation demand, institute a litigation hold. That's texting 49110. The next is issue a legal hold immediately. That is 49111. And the final one is stop the company-wide auto deletion. So it's really interesting, the answers that we're getting here, that the majority of the folks in the room are saying you should issue a legal hold. So Jamie, how do you feel about that? I really don't think I would have issued a legal hold here.
So I think that the preliminary question you always have to ask yourself is, was there a trigger? Was there a legal duty to institute a preservation? And as Patrick mentioned before, in the U.S., our legal standard here tends to be reasonable anticipation of litigation. Elsewhere, it's usually certainty of litigation or imminence of litigation, and in many locations there actually isn't a defined duty to preserve, even in litigation. So here, though, it's anticipated, so you have to ask yourself, looking at these facts, do we have enough to say we reasonably anticipate litigation? Is it a little bit more than 50%? And really going through it, there are a lot of things that would be relevant. You know, you may look at certain factors like, who this employee is. Is she a constant complainer? Is she the type of person that always threatens to sue? Are her threats backed up by anything? What were the grounds for her terminations? Were they legitimate? Was there some risk there, in connection with her termination? Did we contemplate that she probably would sue? The nature of her severance package or her offering? Does she have counsel? All of those factors, when you're looking at it, really should give you some kind of feeling about whether or not this kind of tips the scale over the 50%, right? So based on those facts, I'm personally not sure if I would institute a hold, but it is something that you would look into to better ascertain.
So don't worry, there will be opportunity for extra credit. We have 3 more questions. So you all got it wrong, by the way, if you didn't get that.
That was a trick.
What's that?
Are you on the site? Yes. Go back to old school. Just text it in.
It just well, at least 30 or 40 people were able to access it, so maybe the text message might be the best for you. So on that note, so people are gradually answering. So on that note, I think we can move on to our next topic here.
But before you move on, one thing that some of the other points are intended to convey is there's a difference when you talk about legal hold. A lot of people assume it's just a notice, right? Just an email. Other people assume it's some technical function, like the bottom item indicates, so stopping company-wide auto delete. Is that enough? The standard really has evolved to be notice plus, and the plus is really defined usually by the organization or based on what is involved in that particular case or what is within the scope of the legal hold, and we'll get into that a little bit more.
So the next thing we're going to talk about really is the cost of preservation.
Yeah, so how many of you have been involved in either issuing a legal hold, just raise your hand, issuing a legal hold, or been the subject of a legal hold yourself, custodian of records, not because you were in trouble? Okay, so fair amount. And of those people who raised their hands, how many it was just sort of a one-time or a handful of times? And how many of you are involved in pervasive litigation? Okay. All right, so costs can be different, right? If you're just a company who's issuing a legal hold just once a year, I mean, you really don't have much to complain about in the way of costs, probably, unless it's something that, the case is so large, it's going to cripple your organization, in which case the risk for that litigation is probably equally significant as well. The costs are typically, if you use kind of industry averages, we'll wait until you get the hypo. So why don't we kind of move into to this hypo in particular. So this one, party plaintiff, she files a complaint alleging that retailer Willis Senora colluded with competitors to price fix the cost of Margaritaville frozen drink machines nationwide. The case is expected to last 2 years, and the parties are presently at odds regarding the number of custodians that Willis Senora's lawyers should preserve. What is the average cost per custodian that Willis will incur? So take a minute to think about it. Text in your responses. For those of you who may have a hard time seeing, in the back we've got $189 is number one, which is approximately the cost of one external hard drive. Number two is $190 to $20,000. Number three is $20,000 to $50,000. Number four, $50 to $75,000. And the last is greater than $75,000. And again, we're dealing with cost per custodian, so per individual who is subject to the hold. Give you a minute to let the answers come in. Costs have been something, I will say that folks are, as you're getting more sophisticated within the organization and these programs are actually becoming more and more defined. Companies are internalizing a lot of the functions that were previously outsourced. They're in a much better position to actually track the cost of preservation. It used to be you'd kind of implement a legal hold and it would never die and records would never roll off. But as we're all amassing more and more information, that obviously isn't a very good sustainable business model. So the cost of preservation is something that folks have been looking at and is really driving a lot of the changes around preservation.
You know, an interesting thing to look at is there are things called the GSA schedules. So government agencies are bound to procure services through GSA. So there are a lot of eDiscovery, litigation support-related services that the federal agencies used. Back about a year ago, I filed a comment with the Federal Rules Committee about just how much preservation costs federal agencies, and I think that was the piece that no one really understood. You know, we're always under this mentality that let's save everything. I have infinite storage on Gmail. I can, I can store my stuff on OneDrive, whatever it might be. But when we did that analysis and we walked through the cost of a very small case, it can cost around $600,000 if you have 20 custodians and the matter lasts for more than a year, plus, and then you run the gamut of these charges, and it really affects the cost of justice in the United States. So that's something to really think about when you're issuing your litigation holds. How much cost is this going to impose upon my client? How much extra risk will having these documents for the subsequent litigation impose on my client because I was issuing an overbroad preservation?
One of the things that comes up quite frequently when we have a litigation, we'll get outside counsel on the phone, and we have a centralized process for how we handle preservation requests and legal holds in general. And part of that process is really fielding those requests to our group. We sit around, we talk about confirmation of scope. Is there really, or confirmation of trigger? Do we really have a legal obligation here? If the answer is yes, what is the scope in terms of custodians or time frame or data sources? What's the period of time? Is it something that we need to conduct some preliminary interviews or issue some surveys? Is it too soon to issue the hold? Can we modify the hold at some point? So we're putting together a strategic plan really around what preservation should look like so that we can better ascertain what the cost of preservation is going to be up front and predict it, and then sort of weigh that against other factors, then it's part of that risk calculation. But the industry standards in general right now tend to estimate between $75,000 and $100,000 to preserve per year per custodian. So if you think about that for a second, and you think about an average matter, small case, maybe it's only 15 people who are kind of your key custodians. Larger case, price-fixing case, class action, significant bet the company litigation. You're dealing usually with hundreds of individuals who are under hold, not just for 1 year, but for multiple years, usually 3-4 years. And that's assuming that you're actually doing something to release the hold or roll data off at the end of the hold upon expiration. Those numbers are probably exaggerated for companies who have defined processes in place, who are able to affirmatively control their preservation strategy, who are able to effectively preserve data in place, as opposed to companies who either because of their unfamiliarity with the process or because of the risk approach maybe that their outside counsel has advised them to adhere to, they're having to take these approaches that are extremely broad, which leads to over-preservation, over-collection of data even at the preservation stage, and they're really not able to put themselves in an affirmative position to control the cost of preservation effectively.
Should we look at the responses?
Yeah, let's do it. So first one, it looked like most of you kind of fell into the second category, which was really 190 to 20,000. That would be a dream. That would be great. And then a couple of you, kind of estimated 20 to 50. So what you're saying is most of you were, a third of the cost. Again, assuming that we're dealing with a company who's less sophisticated when it comes to preservation, or hasn't probably internalized this process, hasn't defined a program, and isn't in a position to effectively address the risk of preservation. One of the other things I think is important when people are thinking, well, why do companies take those types of positions if it's so costly? And I think just kind of looking for most people, they appreciate at least the development of the case law today. Most of the risk associated with eDiscovery violations has been attributed to preservation. So most of them, 80% of the time, some estimates 90%, they say that if you can address the risk associated with preservation, you've dramatically reduced the risk in connection with all eDiscovery failures. So most eDiscovery programs usually start with preservation. Companies who are taking this on are usually doing it as a result of the potential for sanctions in connection with preservation violations. So there's been a lot of focus around that really has been kind of the primary driver, I think, for most companies, at least in the United States. One of the other topics I think that's probably relevant to discuss here, maybe the rule changes. I don't know, Jonathan, if you want to, kind of talk a little bit about that in the context of preservation and how, maybe traditionally, how folks have been approaching preservation and how the new rule changes will probably change that calculation going forward.
Sure, we have to address that. The reality for folks is that Civil 1 2005 will likely give us new rules of civil procedure on the federal side. And I say likely because we got 2 more steps left. The Judicial Conference has passed the amendment package. It'll now go to the Supreme Court, and around the April time period, if they approve of it, it'll go up. And then it sits there for Congress to do nothing. Or unless Congress wants to do something. So the rules package has a number of changes, and I think there are 2 really important ones out of the others, and all important, of course. One of them deals with sanctions, the whole idea of did the dog eat my email. And it's a new Rule 37E. In 2006, there was a new rule implemented, 37F, and it changed by nomenclature to 37E, that was meant to be a safe harbor but proved to be completely ineffective. It talked about the routine operation of systems, and then in an advisory committee note talked about when you had to suspend that, and the idea that that would provide protections to government organizations, individuals, and companies was never fully realized. So this time around, the advisory committee worked on a new rule after listening to a lot of testimony about concerns from the government, from companies, that there were real problems out there. There's so much information, there's so many opportunities for things to get lost, yet should people just be sanctioned because something went wrong? And so the new rule, 37E, sets forth in a preamble to what sanctions are available, a number of, I will say, stopping points with respect to if, for instance, a document was lost despite reasonable steps being taken by the entity, no sanction. If the information can be restored or replaced, no sanction. So there's a couple stopping points on the way to then get to what sanctions can be applied. And one of the critical problems that the lawyers surfaced to the advisory committee and known well by judges was the standard for spoliation sanctions across the United States differed. The Second Circuit, following the RFC versus DeJour standard, really allowed for negligent destruction and imposition of severe sanctions, such as the adverse inference instruction, whereas other jurisdictions, perhaps we could say the Fifth Circuit, but certainly the Eighth Circuit, Seventh Circuit, had different standards, most of them focusing on whether there's an element of bad faith present. And that divergence for a multinational company, for example, or for the federal government for that matter, really made a difference, because where were we going to find ourselves in a lawsuit? What standard would be applied to our context? So the new rule really tries to trim that down to one level. And on the first layer, if the sanction doesn't, or first of all, it really focuses just on ESI. They took out documents, or actually they took out tangible things, which is a curious thing when you think about the Yates case before the Supreme Court this week. But they took out tangible things and just focused on ESI, and then created a category where if there was no intent to deprive the other side of the use of the information, then the court can do curative measures based upon the level of prejudice suffered, but then no more. And that specifically means that there was the idea that you can't have adverse inference instructions, you can't have striking pleadings, you can't have default judgment unless there's this true intent to deprive. And then when you get down there, of course, you're subject to all of those sanctions. Now, interesting about the intent to deprive, if you're a terrible spoliator, in other words, you tried to destroy the computer, you jumped up and down, it turned out you were just jumping up and down the old computer case and the computer was sitting in the closet, the advisory committee thought that still should be subject to those terrible sanctions because you're just a bad person, even if you're a bad spoliator. So the new rule allows that. Now, I say all this in saying there were 2, and I just mentioned one, Rule 37E, being very important. And I told Judge Shira Shinlin last week, she was talking about that rule, and I was going to talk about Rule 26. I said, you're talking about the sexy one because that's the one everyone talks about, but it's really like a sports car. You only drive it every so often. I wanted to talk about the minivan. The minivan is Rule 26, 26B in particular, because that's the rule we use in every single case. Very few cases have sanctions. Every case deals with discovery. And every case on the civil side, you have to deal with a thing called proportionality. Proportionality has been in the rule since 1983, but very seldom effectively used. Judges have complained the parties don't present enough evidence or information. The parties complain that discovery costs skyrocket and get out of control. So the advisory committee, and this really followed from the 2010 conference at Duke University School of Law, really focused on could we rework Rule 26B to realize the promise of proportionality. And that new rule I submit to you is really a fundamental kind of crystallization of what the 1983 change was meant to be, and is significant. The new rule takes out scope of subject matter discovery. It is claims and defenses. It takes out the reasonably calculated to lead to the discovery of admissible evidence, not there anymore, okay? It puts into place a proportionality in the same sense as relevance. You're entitled to obtain evidence or discovery of evidence or information that's both relevant and proportional, and then it moves up the factors that used to be down below about amount and controversy, et cetera, and actually takes amount of controversy and does not place it first anymore. It puts it as a second factor, and it also adds a new factor in that rules with respect to the relative access to information, or relative availability, I think. Don't have the exact words, but go look at that rule. That is the minivan. You take it to soccer practice every day. You get the kids. It is the workhorse rule, and it's substantially changed. And the reason why I think it's so important is because for an effective system of court resolution of disputes, it has to be affordable. Affordable for mom and pops, affordable for big companies, affordable for individuals who are pursuing their rights. And if we're going to have a system that's going to protect individual rights and have the proper view of you know, what the law is, you need to be able to get there and be able to try things. And what we're seeing, you look at these costs that Jamie and Patrick just walked through, $75,000 just to preserve for one custodian for 1 year. What are we doing? And the average individual, you know, with a small business, how do you actually possibly start seeing yourself complying with some of these onerous kind of demands if you have to spend that kind of money? So that rule, I would say those two changes are significant. There are also changes to Rule 1, there are changes to Rule 16, there's a rule change to 34, on and on. We'll go for days if we talk about it all, but I think those two rules changes are particularly important. And again, if you're finding yourself with a dog at your email, this new Rule 37E, I think provides great guidance. And I'll also say, for you purists and scholars out there, the advisory committee notes accompanying this rules change is the longest by far of any package of advisory committee notes, and they're real nuggets that are buried in there.
Has the comment period passed for all those rules?
Yeah, the comment period is passed. There were 3 public hearings. The advisory committee met in the spring, standing committee met in May, and then the full judicial conference has gone through the voting and passed it on in October. So it is a done, baked deal. You can find it on the federal court's website, or the federal court's website on the rule stuff. But it has passed the comment period, and it just awaits the Supreme Court passing it on, and then Congress has the opportunity, of course, in Rules Enabling Act to modify or do whatever it will, or do nothing.
And if nothing, then it would go into effect about a year from now.
It would be December 1st, 2015.
Yeah.
Judge, do you want to comment maybe briefly on your thoughts on the rule, or particularly with respect to cost and just hopefully improving just general accessibility to the courts amongst plaintiffs?
Well, the real problem with the eDiscovery is obvious, which is in increasing volume and in increasing costs. And so there has to be a trade-off between the reasonable relevance of evidence and the party's ability to retrieve all of the documentation that it has. A perfect example being emails, which are forwarded or reply to all, and emails go out to people throughout the company, and someone inadvertently sends an email to his wife along with at home along with the grocery list, and does that have to be produced? And so there's a limitless volume of material that's there, and I think the courts are always looking at some kind of a balancing process to see what's fair, while ensuring that nothing is kept from disclosure that should be disclosed. And this rule is probably a beneficial step in that direction. The eDiscovery is moving so fast. The Rules Committee process, as most of you know, is ponderous and slow, as it should be. But it takes 5 or 6 years to get any rule implemented. I used to chair the Federal Advisory Committee on Rules of Evidence, and and it takes forever to get a rule implemented. So it's going to be hard for the rules process to stay ahead of the explosion in technology in this area, but this is probably a good step.
Yeah, I think that's exactly right. The advisory committee tries to be very technology agnostic to make sure we don't get caught up with nomenclature. You might remember in 2006 they removed the word phonograph from the rules because everyone wasn't really using a phonograph anymore. So what they've tried to do is go back to the bedrock principles of proportionality, I think, and really spell them out in ways that we can apply it no matter what we're dealing with. We're dealing with widgets that are flying in the air telling us things like our cell phones do now. And then on the sanction rules, I think they really tried to focus, though it was on digital, not try and tie it to, as some people accused in the 2006 changes, things like backup tapes or stuff like that. They really tried to learn the lesson and say, how do we create something that has lasting value regardless of whether it's a dog or a flying computer.
So before we move on away from this topic, I wanted to bring up one point, and I get this question a lot internally and from outside counsel, who typically says, I don't understand why it could cost $75,000. We're just talking about sending an email, a litigation hold notice. So the duty to preserve, which we talked about before, really confers that notice plus, right? And the plus is ensuring that nothing's going to happen to the data, that it can't be altered, much less deleted or destroyed. And the latter, if you're dealing in a large corporation, dealing with common sources, they typically involve communications data. Could be email, could be voice communications, your audio, could be chat in multiple sources, and typically involves some type of documents, maybe stored on a SharePoint site or a file share, either domestically or internationally. So the cost of preservation for the data sources is going to depend on a lot of things. It could depend on the type of system that you have, whether you can go in and just key in who the custodians are and the time frame and keep that data there in place. Whether, if you're dealing with some type of structured application, you actually have to suspend the routine deletion within the system, and the way you do that could be very different. Sometimes it requires you to do it for the entire system as opposed to just for certain queries or for certain individuals. If you're dealing with data that resides outside of the United States, there's a lot of coordination that you have to adhere to, particularly when you're dealing with data privacy, data protection laws in some jurisdictions. And if it requires collection in most jurisdictions, that's going to constitute processing of data, which requires you to go through some additional hurdles and in many cases obtain consent, or if not consent, a certain level of approvals with respect to the approach for that data. If you're talking about voice data, you could be dealing in a certain company or organization. We have more than 2,000 different applications used for voice. Each have their own unique type of capability. So you're dealing with, even though it seems very simple, and you pick maybe 5 data types that you may need to preserve, you're dealing with very nuanced approaches for every single data source. And again, this is just one case. And then you multiply the amount of man hours that's needed in order to discuss these issues, to develop the planning, to implement the plan, to manage it effectively over the life of the legal hold. $75,000, when you put all that together, actually seems like you really got yourself a bargain. Let's move on.
So let's hear from our 2 panelists that have not yet heard from. Dan Epstein.
Thank you, and thank you to the Federalist Society for hosting this panel. I'm going to change directions a little bit. We've heard about what companies' duties are to preserve records in ESI when there's litigation holds and under what standards those litigation holds apply. The other question, of course, is many of you represent clients who are subject to enforcement actions by the government, or you're litigating against the government, or there's relevant congressional investigations that take place. So what are the duties of government agencies, and especially lawyers at government agencies, to preserve records? And I know we have a potential hypothetical up here that we could jump to. Fred Fed is an attorney in the General Counsel's office at ABC, a new federal agency. After 36 months, Fred settles a FOIA litigation and removes the legal holds that he placed on a dozen senior agency officials. He sends the employees an email telling them that they may now delete all email messages that they were retaining for the legal hold. The employees complied, deleting 24 of the 36 months of email. Were Fred's instructions and the employee's actions defensible? The first answer is yes, because the legal hold had expired and the duty to preserve no longer existed. Like companies, ABC has the right to manage records efficiently, and routine destruction should resume. Second answer would be no, because government agencies are obligated to retain everything forever, regardless of whether a hold exists. The third would be it depends on whether the employees printed their email prior to deletion. Fourth, it depends on how the emails are managed and archived and whether another copy is available. And you can tell these are questions for lawyers with all the "it depends." And the last, of course, is not sure. So we're seeing kind of the second answer, but with a lot of these issues are kind of open questions because the main statute that applies to federal agencies in terms of preserving records is the Federal Records Act. And what the Federal Records Act enables is for federal agencies to issue their own rules and guidelines about records preservation. So you might have some agencies that say printing out a copy of an email is sufficient. You might have other agencies that say all of the electronic data, even if it's printed out, still has to be stored in some way. And one of the interesting developments that has happened recently is that the Office of Management and Budget, together with the National Archives, has actually issued guidance to federal agencies that by 2015, all records would be stored electronically. You can imagine that with something like the recent IRS scandal, where you have questions of both congressional investigations and actual litigation, that this becomes a tricky question. One of the allegations about Lois Lerner is that she had email records that were on certain tape drives that were lost or destroyed. We don't really know the truth behind that. But at the end of the day, if the IRS had a regulation that said these have to be printed independent of whether there's electronic records, but the Office of Management and Budget sends out a directive that says don't keep paper records, you realize that there could be certain conflicts in practice. One of the things, and I see that we kind of got a tie between the not sure and the no, because government agencies are obligated to retain everything forever. In addition to what the Federal Records Act requires, notice there's also, for those who are litigating potentially against the White House, the White House itself doesn't follow the same records preservation requirements that federal agencies do. The White House, of course, has the Presidential Records Act. And what is unique about both the Presidential Records Act and the Federal Records Act is that agencies or the White House have the ability to dispose of records. That doesn't mean throw them out. That means they can make certain determinations in consultation with the archives that emails or certain other types of records no longer actually have to be held at the agency. They can be deposited to the archives. So you can imagine that there could be circumstances in which, if, like in this hypothetical, you represent a client who's dealing with FOIA litigation, agencies typically can respond that they conduct reasonable searches. The rules about anticipation of litigation don't necessarily clearly apply to agencies in the FOIA context, and so you can have oftentimes agencies dispose of records that they believe are no longer relevant to some congressional investigation or other thing, and then of course you can't essentially discover those records. What's interesting, and I bring up the IRS example, there's an interesting kind of conflict that you see with the fact that there's not a lot of case law on these government records preservation questions. We now know that in June of this year, in June 2014, there's the famous letter that the IRS sends to Ron Wyden, who's the chairman of Senate Finance, no longer to be chairman, and also sent to Dave Camp, who's the chairman of House Ways and Means. And what this letter said is that the IRS is doing all that it can to try to preserve records. It actually indicated that in response to their investigatory letters that a litigation hold was issued, which is itself interesting language, because in that case, that was a separate litigation hold issued just in response to a congressional investigation. So you can see that some agencies interpret the term anticipation of litigation broadly. Some agency lawyers might advise their agency clients that in the context of a congressional request letter, whether it's a official inquiry or whether it's simply just a letter notifying or requesting documents, that certain agency lawyers might advise their clients, this is in anticipation of litigation, even though this is a congressional committee. And so in that case, you saw that litigation holds were issued, and then, of course, they made the disclosure that we can't find Lois Lerner's emails. They were somehow inexplicably destroyed. But I use that example because I think it's important if you look back into what happened in July 2011 when Congressman Dave Camp, before the IRS scandal became a very big issue or a public issue, sent a letter to the IRS asking them to produce certain documents responsive to a request and allegations that he got about certain conservative groups being targeted, and yet you see in that case the IRS clearly didn't issue a litigation hold in response to Congressman Camp's request for investigation. You can imagine that the rule that they applied in response to Senator Wyden ought to have applied back in 2011, and you would have avoided this kind of mysterious, the dog ate my emails type situation that the IRS claims happened with Lois Lerner. In July 2011, if there was a duty to preserve records, that duty should have meant that those emails were somehow either printed off or stored. And in fact, when you look at the IRS's regulations in that case, it very clearly indicates that Lois Lerner had a duty to print out those records. Again, it's quite interesting that you see this directive, this transparency directive coming out of OMB and the archives basically in 2012 saying we don't care about whether agencies preserve physical records as long as they just store them somehow in their email files or elsewhere. The other issues that come up with this, and I know I've only got a few minutes, is basically, well, what happens when you're in this context? You're representing a client, it's FOIA litigation or some other type of defense against an enforcement action, and you believe that the agency has destroyed records. Well, in that case, a lot of the common law about spoliation and being able to have a judge instruct the jury about a negative inference also applies in the context of agency investigations and congressional investigations. And ultimately, Congress has a very big power in those cases to say this was obstruction of Congress. And that's one of the things that I believe Cleta Mitchell in the True the Vote versus IRS litigation actually raised that issue to the Justice Department and raised it to members of Congress of whether, in fact, this is evidence that there is obstruction of Congress. And of course, you can also imagine that if there's an intentional destruction of records, that's a federal crime for federal employees. And then there's also statutes about whether, in fact, this was something that was destruction without authorization. And what's at least useful about certain rules that the National Archives puts out is if all of a sudden records go missing or the agency can't explain what happened to the records, well, there's a very good check to see whether the agency was following the rules. You can FOIA, you can ask, when you lost those records, did you notify the archivist? Rules very clearly indicate that the second records are inexplicably lost, missing, whatever it is, the agency has a duty to immediately notify the archivist. And if that doesn't happen, you can potentially draw negative inferences from that. So that's all I'll say about that. I'll just say one other thing, which is, of course, there's special duties for government lawyers, and there's actually case law on this. Those of you who are representing private companies or in commercial litigation, obviously ethical duties are of the highest concern. For government lawyers, the case law very clearly indicates that even if your client wants you to cover up, do something else, advise to the best of your ability about what you believe happened with the records. As a government lawyer, they actually have a higher duty to actually disclose what in fact has occurred if it turns out that there was no notification to agency heads about destruction of records. As a government lawyer, those duties are higher than lawyers in private practice. So I will turn it over to Julie to talk about
really
social
quickly,
media.
Daniel, we've got two former government lawyers over here, so we just wanted to sort of provide another perspective too. A lot of this, as we've learned earlier, it's about cost. it's about efficiency. We're dealing with a variety of disparate and ad hoc systems. None of these things work as companies. Why would we expect them to work in the federal government? Interesting thing that came out a week and a half ago. The IRS just sent out a procurement for a tool called Semantic Enterprise Vault. What that tool does, it retains all of the emails sent or received from the agency. The SEC has something like this. So what we should be thinking about sort of going away from this, I think it's more of an information technology problem. I have a feeling that if we are going to require people to over-preserve or to retain everything, we need to impose that obligation upon them and give them the resources to do that. At certain companies, they are required to retain 5 years of email because they are in certain market sectors. Certain government agencies might consider the same thing. But imposing those information technology requirements on them, I think, is important, not just mandating go save stuff without any sort of appropriations for it.
If I could chime in, and Judge, you may want to add to this later. I think one of the things that I think isn't appreciated is the magnitude of documents that the government's dealing with when you're looking at the definition of what constitutes a record. So in most companies, we define records as things that are actually important, and you'll have a category, a taxonomy that breaks down the records that you're either obligated to maintain pursuant to some regulatory or legal requirement, or things that you need in order to conduct business, and everything else it can be disposed of at one's leisure, right? With the government, pretty much everything that's done in connection with your job would constitute a federal record required for retention purposes under the Federal Records Act. Very different, retention versus affirmative preservation duty. So when you look at the hypo, and we kind of get into some of the nuances of the answers, the reason that they're tricky is that you're really balancing between this general duty to retain a lot of data versus a specific preservation obligation in connection with litigation, which once that's lifted, if it was so important, usually to your job, you're going to be obligated to retain it as a record anyway. So it's almost you don't really gain the benefit of releasing the hold. So the second point is that the government must retain all documents. It actually doesn't in theory, but in practice almost. I mean, you're dealing with usually virtually 85% of all of the documents would otherwise constitute a record under the Federal Records Act. So to Patrick's point, the reason it's an IT issue, it has to do more with the volume of data that the government is required to retain and the inability to effectively manage that without some type of technology to intuitively identify or auto-categorize what would otherwise just be waste, right? And so there are different approaches that agencies are taking, but part of their difficulty is really because of the volume, lack of resources, and what it would otherwise take in order to effectively combat the problem.
All right, Julie Reiser.
Thank you. As we were talking as panelists before we decided on our topics, one of the things I was noticing is that everybody's thinking about what do I advise my client in the obvious way? What would the IT folks be able to gather and collect? And so there's some non-obvious places that you also might consider looking. So for somebody who takes depositions right and left, the first thing you do is you go online and you find out about the deponent's presence online. What are their Facebook posts about? Do they tweet? And so as I started exploring this topic, I realized both that companies are frequently not paying attention to what's going on online with their employees. And secondly, there's a lot of bring your own device rules right now where people are using their own handhelds, their own iPhones, and they're doing work on their iPhones. And the idea that companies, while they may know to preserve laptops and they may have all of the systems in place, may not be reaching out for the iPhone and that kind of thing. So I think we have a hypothetical that goes to the notion of a Facebook account and how we can run into problems with that. For the voting.
Yeah, we've got to switch screens here. There we go.
There we go. So Wally Widower, a surviving spouse in a wrongful death case, receives a document request for printouts from his Facebook page, along with a printout of certain information and photos that defense counsel obtained from what was publicly available. A few of Wally's private photos on Facebook are not that flattering, and he has a few politically outlandish statements amongst his friends. You are Wally's attorney. How do you advise him to handle the content on his Facebook page? Do you advise him to restrict what is made publicly available?
Julie, we actually, sorry to interrupt, you can't see it because it's so tiny, we had to minimize the language.
Sure.
So the first one, if folks can't see, I'll just read it here. It's restrict access to your page. Do you advise him to restrict access to your page but don't delete anything? The second is, do you tell the client to clean up his Facebook page? Do you instruct Wally to delete the profile in full? Or, as Wally's attorney, do you yourself send friend requests to key defense witnesses and say, two can play at this game?
To be clear, I think there's several right answers and there's several wrong answers. It's all context-based. But this is an ethics panel, and therefore that won't come as a surprise to anybody. Quickly, the idea that social media is prevalent is going to come as no surprise. There's 1.28 billion Facebook users. Twitter administers 500 million tweets every day. 88% of all business executives use LinkedIn. And so when they've surveyed companies about their litigation hold policies, actually 20% have gone to social media accounts. And 41% of companies surveyed have preserved or collected data from employees' mobile devices. So it's something to keep in mind as you're looking at a litigation hold and the relevant actors is, do you have everything? Do you have all of the pieces that you need? And even if you don't need to preserve those, does it make sense as your counsel to go online and find out a little bit more about these key witnesses? The most frequent uses of social media in litigation are for personal injury and employment disputes, typically to impeach the witness, and in trademark litigation to be able to show that there's confusion for consumers as between the two trademarks. So back to our friend Wally Widower, and it looks like the most popular answer there is number one, which is that you can decide to restrict what is made publicly available. And that's fair, but there's plenty of case law out there that says as long as you present it to the outside world, it is still discoverable. So it's a good first step, but it's probably not sufficient. Do you instruct the paralegal to tell the client to clean up his Facebook page? Seems a little sketchier, right? But there's actually ethical advice that says that if it's not relevant, you can instruct your client that way. And I was thinking about what would I give as an example? So forgive me for the sports analogy, but let's say you're in North Carolina and your client went to Duke and has Coach K and Duke stuff all over the Facebook page, and you think that you're going to get a predominantly Tar Heel jury. And the claim is something totally unrelated to sports. In that situation, it might be okay to clean up your Facebook page and not present as such an avid Duke fan because you don't want to have an automatic first poor impression as to the Tar Heel folks. But that's sort of as far as you can really go, because there's still this ethical obligation not to destroy or misrepresent evidence. And so the issue with our friend Wally Widower is that he not only, this is actually a real case, it's called Allied Concrete versus Lester. The client deleted his Facebook page and then signed a certification in discovery saying, I don't have a Facebook page. And then in his deposition, he denied ever having had a Facebook page, which is astounding because when the Facebook document request came in, it was the cover page of his profile. So not quite the sharpest pencil in the box. The other side was able to engage a forensic company to discover a lot of the old pictures and that 16 images had been destroyed. And I think this is another important consideration when we're talking about social media. It's not really gone sometimes, right? So it's in a cloud and it can be discovered. But where the images are destroyed and can't be recovered, what happens in that situation? So in the cautionary tale of Mr. Lester, sanctions were granted. There was both adverse inferences and fines. The adverse inference was when the witness testified and also at closing argument, the judge instructed the jury to presume that these 16 deleted images were harmful to his case. There were fines of, I kid you not, $722,000 in this wrongful death suit, $542,000 against Counsel, $180,000 against the plaintiff, and then additional costs and fees to pay for the forensic review that the other side had to do in order to try and recover this evidence. And then, when all that was said and done, and by the way, Wally Widower still won his case in several $1 million. But the attorney was not so lucky, and the attorney ended up having his his license to practice law suspended for 5 years because what he had done was dishonest and had destroyed evidence. So, we've talked about this idea that when it comes to social media, one of the things that you want to look at is relevance. It's okay to tell somebody to clean things up. It's okay to tell them, as long as it's not relevant to the litigation at hand. And so it's a fine line, and if you get on the wrong side of that line, there's real consequences for having done that. Jonathan spoke a little bit about this new Rule 37E and curative remedies versus sanctions. I had the same reaction to it, which is because a lot of social media is cloud-based, if it can be recovered, you're usually not going to get to the sanction point unless you have the email from the paralegal saying, my attorney is telling me to tell you to clean up your Facebook page. And when that happens and you have the bad conduct, that's when you tend to get striking of pleadings, dismissing the action, and adverse inferences. So the real question is both, was the information relevant, and did it result in substantial prejudice? When you have relevant information and substantial prejudice, then the next question, which leads to the adverse inferences or the striking of the pleadings, is it willful or in bad faith, unless you're in the Second Circuit? And then I think negligence at this point is still enough. And I guess finally, in terms of advising clients, the one thing that I've seen that seems to hold is in litigation holds, in retainers, having instructions to the client that make it clear social media accounts. It's not just emails, it's not just things that are maintained on your iManage document retention systems. The second thing is to make it clear that just because your Facebook profile is private does not mean that it's protected from discovery. I think people would assume that that might be the case. Some litigation and holds and retainers would say social media ban. You just cannot talk about this case. And that has to be the most prudent thing to do as the attorney who does not want to preview every single post to make sure that their client is doing the right thing. And finally, I think as an attorney, if you can avoid, as you're negotiating back and forth in Rule 26B, do not give unfettered access to your client's password to Facebook or Twitter or LinkedIn. It should be as narrowly tailored as you can to avoid the unpleasant surprises that might ensue.
Julie, if I could add one more point, I think that's really important, particularly if you're representing corporations who oftentimes can't control their employees. My company not included, of course. But one of the things that's important to look at is really the standard in connection with eDiscovery, and it really is possession, custody, or control. So it's easy to think about, well, do we have an obligation to produce documents or preserve documents that we possess that are stored in our network? Obviously. Custody, within our custody, they're here, or maybe they're stored on some cloud provider, but we contract with them, so yep, I've got custody over those. But control is really an interesting one, so there's a lot of case law, around that, and the most effective advice, I think, to give clients is to ensure that they have policies and procedures at a basic level to address things like communications. If you are going to be, for example, communicating about corporate information or anything in connection with your job or your business, it needs to be done on approved sources, not your personal Gmail account, for example, or some other mobile application that you've downloaded to your device, or you're texting on your personal phone or the like. The second type would be a social media policy, not only for social media sites and applications for the company, but for employees with respect to what they can or cannot say. That gives you some ability to control them, to terminate them if it was something that was derogatory, defamatory against the company, or something that could potentially put the company at risk. The third, though, is really the education component. It's not enough anymore to just rely on those policies or procedures and say, well, I can't really control my employees. We have this great policy on, communications, and, I can't control what they're doing in the field, for example. If you know that that this conduct, this non-compliant conduct, is occurring almost as a matter of practice, then as a company, you have an obligation to do something extra. Either it's something in the way of education, it could be communications that go out monthly or quarterly, reminding folks to communicate on approved means, or perhaps if it's so pervasive, arguably you then have an obligation to implement some type of bring your own device program internally, or explore ways for certain employees to conduct their business, maybe it is client-facing communications or the like, with approved means in a compliant fashion. And I think that's where companies are starting to be a little bit more proactive because they recognize they can't really just rely on those policies anymore, and they really have to address kind of the way we're all communicating going forward.
So if any of our panelists have any kind of brief follow-up, but we want to save a lot of time for questions from the audience.
And I just have a few points I want to make, because getting back to the attraction of getting you in here was about canines, right, and eating. And I have a golden retriever, and they really do eat stuff. I mean, documents, shoes, walls. So the reality is sometimes you can have things that just accidentally go missing. Sometimes mistakes happen, and then quite frankly, we know perfection is not the standard. There's a raft of case law that judges who have dealt with this issue, mostly on a district court level, have said perfection is not the standard 17 times a Sunday. And it's really important to understand this when we start talking about, what is the consequence for when something goes missing. And I would say there are 3 C's that come to mind: culpability, criminality, and context. I say criminality because when it actually gets to the appellate courts or to the Supreme Court, it's usually in a criminal context. Many of you are aware of the argument this week in the Yates case here in the Supreme Court, dealing with the 72 red grouper that were thrown overboard. It's a commercial fisherman. And in that case, it deals with the successor Enron statute on document destruction, as to which the tail end is about a tangible object, kind of like your federal rule standard. And so the destruction of that tangible object, the fisherman is prosecuted under the corporate document destruction statute. And there was a grave amount of doubt voiced in the Supreme Court, but then a lot of confusion about what do you actually do. And the real concern was, have we really overly criminalized certain conduct? And they're really focusing on prosecutorial discretion. But in the civil context, there seems to be this sense that there's something missing. Oh my goodness, there's really, really a problem. So we've got a hypothetical up here we're going to want you to vote on real quick, okay? And I'm not going to spoil the answer here. It's not a spoliation thing. So we've got a Department of Justice bringing a False Claims Act suit against Pharmaco, or Pharmacon, pursuant to which Shady Sal, that's a great name, curse your parents, has been placed on legal hold. Hard drive fails. Could that ever happen? The IT rep says it can't be recovered, and wow, look, restoring the machine to factory settings. Jill Justice, good name, DOJ trial attorney, gets wind of this and has filed a motion for sanctions alleging spoliation of evidence. As a newly appointed federal district court judge, congratulations, by the way, do you rule? And you got 4 choices there. You put Shady Sal in the clink for contempt. Number 2 is you rule that Pharmacon and its counsel spoliated evidence, but deny the motion for sanction on grounds that all evidence indicates it wasn't intentional. Your 3rd choice, dear new judge, is that you rule that the company and its counsel spoliated evidence. You grant a motion for sanctions, ordering an adverse inference instruction to the jury. And the 4th is you're going to rule that the company and the counsel spoliated evidence, grant the motion for sanctions, ordering Pharmacon to attempt to remediate the lost data and pay costs associated with the motion. So you got 4 choices there. Let's see your votes.
One of the interesting things to...
You can't read what they are. Again, the first one is you put them in, throw Shady Sal in clink for contempt. Oh. Yeah, what are the numbers? They want to vote, Patrick. I can't even read them.
It's 49331 for...
311.
Oh, I'm sorry. The phone number you're texting to is 22333. And the first answer is putting Shady in the clink. That's 49311. Pharmacon spoliated but deny the motion on grounds that conduct was unintentional. That's 49324. Pharmacon spoliated, grant the motion and order an adverse inference instruction to the jury. 49355. Finally, Pharmacon spoliated evidence, grant the motion and order Pharmacon to remediate the data lost 49356.
Sounds like American Idol here. Vote for your favorite now. We'll see who gets to the next round. Well, as you're voting here, I'm going to give something away. Me, if I'm appointed here, I'm going to say this is all wrong. None of those answers are right. Because we're missing the context here, just like the dog. If Oliver North and Fawn Hall are sitting next to the dog, feeding the dog the emails, you know, it's a different context, right, than the dog just grabbed it off the table. And oftentimes we jump to conclusions. So I'm not going to name certain cases, but there's a case out there where a judge really got upset because text messages weren't saved from sales reps. Okay, they weren't saved, but did anyone go and say, well, what was a sales rep really doing with text messaging? I'll be late to the meeting, maybe, but is that material? Or do we really think you're taking text messages and, you know, texting off-label use for this drug? Probably not. I mean, so it's like, stop. What's the context of what's really going on? Or we lost the laptop. So we lost a laptop. Well, did someone collect the information before we lost the laptop? Then who cares? Is there a backup? Then who cares? Or maybe Shady Sal here, maybe she's not a key player. Bad name, but doesn't mean that she was at the center of the conduct, right? I mean, it's just unfortunate naming from the parents. Different lawsuit. But the reality is, do we really know much about this? Or, by the way, what if Shady Sal in Pharmacon, she's really dealing with adverse events, right? What happens with adverse events? We get reporting. Well, under FDA regs, you got to have a separate adverse event reporting database. All the information is going in there. So do we really think that the company said, well, Shady Sal, you've got it on your laptop, keep it for us? Of course not. That doesn't pass any muster. So there's always, you got to pull the onion. What's underneath there? What's really going on in any given case? So I tell the Justice Department, thanks very much for your motion, but I think you need to get into a little bit more discovery or discussion, quite frankly, about what's really going on. And by the way, even if it turned out the person was a key player, can we recreate the information? Can we reconstitute it by looking at other emails back and forth, or other documents, or other ways that we can get testimony? One of the things that the new federal rule 3070 is great about is really laying out that you can either get replacement evidence. And replacement evidence doesn't mean you restore it so you magically had a backup. But what if we had stipulations of fact about what was there or the information? Because again, lawsuits should be about claims and defenses, not spoliation. It shouldn't be about some other series of events that take the party out of a position to be able to litigate fairly a claim or defense, right? So if there's true prejudice, like the car is missing that was the real thing, that's a Silvestri case, a whole line of cases. That's pretty important. We're going to have to remedy that. But if it's, 10, 20, 30, 40 people in a company, oh my goodness, we lost their custodial files. We can't see what these people had. Okay, you said that. What does that really mean? Does it mean that, well, if they're in Pharmacon, maybe all their information is really in centralized databases? It doesn't matter. Maybe all the emails they had, other people were copied on it. Step back. What's really going on here? And by the way, maybe when you look at it, the IT people were the ones, when people left the company, they were turning it over, reusing it. They didn't have any intent to destroy things. Was the company wrong about not having a litigation hold that saved everything? We just said perfection wasn't the standard. Stop. Everyone needs to step back and really take a moment to breathe and say, what's the real thing going on here? Is there bad conduct? Did they feed the emails to the dog? Or is something missing because of inadvertence? Or maybe they didn't have a perfect policy. Maybe there wasn't a perfect process. But what's the ultimate prejudice here? Where is the materiality on all the things that are allegedly missing? And can we really have a fair trial? And I'll tell you, a lot of times people are like, we got 20, 30, 40 people. Their stuff is missing, this custodial file. Well, by the way, in records management for federal government or for individual companies, there's absolutely nowhere that says, make sure you keep Bob Smith's files forever. It's no, you give it to the successor. You put it in central files. You get it, in the end, for the federal government. It goes into national archives. It's really important. Sometimes you can find it correlated to a person, sometimes not. But it was more important for the federal government to know this is what the agency decided. This is what the agency did, not Bob Smith. And sometimes Bob Smith's important too. I don't need to knock Bob. But the reality is here, we get into this mindset with electronic documents, electronic information, and computers, that everything must be there. Don't make assumptions and let people really come in. If I'm the judge, I'm gonna say, give us the evidence to know what's really there. So, this is back to the new rules, and what you really should learn and know about this area is, don't jump to conclusions about why the dog ate the email, or that the email was important, or you can't find the important information from the email from somewhere else.
practice group session, your questions are particularly important, and so we want to hear from you on that. You can direct your questions generally to the panel, and if the panelists had any follow-ups, they can use the context of answers to your questions. So, as always, we ask that you really do ask a question and not express an opinion or make a statement, because really this is a practical session, and it's designed to present real questions and real issues and give everyone a practical point. So with that, question.
On the first slide, I noticed you cited the Zubilaki case in the Southern District of New York. And my question to the panel is Zubilaki good policy in your view? And second, to what extent is Zubilaki codified by the new rules to which you've referenced?
Well, two things on that. Arguably, the new Rule 3070 in the discussion is meant to, if not reverse, at least pull back on the ruling in Zubilaki with respect to the adverse inference. So it's no longer good law after the rules go into effect next year. The Pension Committee case, which followed on another Judge Shindlin case. So that is an important element. The other aspects of Zubilaki, though, I think still have some vitality with respect to the duty of counsel to supervise, with respect to the good advice about litigation holds. But on that, notice that the Second Circuit in the Chin case purposely said that you don't necessarily have to have a legal hold in every single case. It's just a factor. It's not a per se negligence in the Second Circuit on a negligence standard, which gets wiped away under Federal Rule 37E. So there are elements of Zubilaki is still good reading and understanding what it is, but know that come December 1, 2015, there are elements that are no longer good.
Good morning, Lisette Garcia, FOIA Resource Center. Thank you so much for your remarks. So my question is the double standard in FOIA litigation. Why do you think that there's never a consequence for spoliation in the FOIA context like there is in the rest of civil litigation?
Well, I think there is a consequence. If you're in FOIA litigation and there's destruction of evidence, yes, there's a consequence, right? And I think the case law is pretty clear on that. However, if a FOIA request comes in, is there a similar process, a legal hold process that exists at the agencies? There's a retention process that exists around the FOIA materials, but it's not as succinct as it is for litigation.
Government attorneys are never sanctioned the way are in civil litigation if records are destroyed in the meantime, even during FOIA litigation. It's been my experience. They just don't get sanctioned the same way that a regular attorney at like Gibson, Dunn, or whatever any of the firms do.
So you had evidence of, during litigation of
Courts never punish the government attorneys when documents
SEC, Aguilar, I could probably name a bunch of cases that it's happened.
Yeah, and I would just say, I mean, you know, in the FOIA context, part of the problem is, you know, how do you prove that any spoliation occurred? You know, at the end of the day, it's a question of the government is searching for records. I would just also jump on one of Jonathan's points, which is actually unique in the FOIA context, is now there's litigation on this whole question of text messages, SMS messages, and these sorts of things. And now you see practitioners putting in their initial FOIA requests the duty to preserve those kinds of communications.
Yeah, I was going to say the one case that comes to mind, and I don't remember the caption, it's the Carol Browner left the EPA in 2001, and her hard drive got messed, and that was a FOIA case. Judge Lamberth, I think, did hold the agency in contempt, so there was a contempt sanction, but did not sanction the individual lawyer. You know, I don't know. That's an element I think judges are really hesitant. And quite frankly, Your Honor would probably admit this, and it's a good thing, honestly. The judges are really hesitant to really sanction lawyers in the first place, and I think the elements there in the electronic age, people and judges rightly kind of realize there's some element of unknown or mystery to it that you just don't want to hold people, you know, without clear and convincing proof that they were purposely trying to evade, destroy, or delete for interfering with a FOIA or with a proceeding.
And I'm happy to share those cases with you if you email me afterwards.
Bill Hall, unfortunately, I am an attorney for the government.
A compliant one.
Actually, I'm a white-collar prosecutor, and so I kind of want to bring up something that's a little bit of an elephant in the room, perhaps. You know, my biggest fear is the evidence I have no idea exists, and you know, and it's kind of the concern you get with the more record keeping that we have and the more public we are about it. 5, 10 years ago, people would do all sorts of stupid things in company email, government email, and now it seems like that's happening much less. Like if you go look at indictments and the evidence behind the indictments, for example, in public corruption cases, all of the time, these people who are doing deliberately really bad things aren't using their official email. They're getting a burnable Gmail account, or even worse, an offshore email account, and using personal email accounts and other sorts of things completely outside of what is being controlled and subject to record-keeping requirements. And the concern is that the more public we make it, that you have to do A, B, C, D, and E, we have a litigation hold. I mean, this is definitely going to catch all the people that are unaware they're doing something that's wrong or subjecting a company to liability. But the people who are knowingly doing things that are really, really bad are just going to go completely dark. I don't know if it's a solvable problem, but
I'll take that on, just being at a large a bank, and so we're dealing with a lot of the issues, and I'm sure you're looking forward to prosecuting. So one of the things that I think is incumbent on us as eDiscovery practitioners or as prosecutors or as defense lawyers, you just have to get more savvy about how you find the information. They still have to do their job. They still have to communicate. You can't effectively trade if you don't have communications with clients, or you're not placing trades or using systems. So the information's still there. It's just that the proliferation of it, the volume that we need to search through, the magnitude is so great now. So you have to be smarter. You have to know your data. You have to figure out the flow of communications. What is the life and the day of a trade, for example, if you're dealing with financial institutions? So walking through that, figuring out what systems are being used, what are the opportunities for communicating, even in a compliant fashion. Then it's about volume, right? How do I effectively search through this kind of volume quickly in order to find the information? That's where the technology and the process comes into play. There's been such a tremendous advancement in the technology, really the past year and a half, 2 years. A lot more analytics are being used in order to locate information quicker, faster. But also looking at these non-traditional data sources. So folks are certainly moving away from email. Nobody has time to type email anymore, particularly if you're engaged in insider trading or something. So they're doing it on chat, right? Or it's voice, call me. Voice is now being recorded, depending on the nature of the transaction that you're looking at in the trader. So voice is becoming the hot new data source for most of us. Looking at other non-traditional sources that may not be sanctioned by the company, like mobile applications, ask for it in the discovery. It goes back to possession, custody, and control. Fight for it. Depose the 30B6 witnesses in the company about where data is stored or those policies and procedures. But targeting the core of the communications, that's really the first place to go.
And
I have
use
one more comment,
26G.
Julie Reiser had to say something.
It's just, to me, it's a burden shifting question as well. So when Jonathan was talking about the courts and how relevant is this information that's missing to the core of the dispute, I think I'm frequently with you. I have no idea. I know this is a key player. I know this information is missing, and I don't know that he took a jackhammer to the laptop. I just know that it should be there and it's not. And I think that's really what the courts are going to have to grapple with is, who has the burden of showing that it wasn't relevant? Or, well, I guess obviously that sort of assumes the answer. That would be the direction I would like to see it go if there's missing information.
But I will say, as a prosecutor, I mean, you'll get more than anybody else, right? Because people actually have an incentive to play nicely, and so sometimes, not that you don't always on a basic level, but they want to play nicer, right? Because you just want it to go away. So I think those negotiations, you have a lot greater opportunity to get that information through a very conciliatory process than a traditional advocate might in litigation.
And every attorney in this room is obligated to conduct a reasonable inquiry under 26G. You as a prosecutor have the opportunity to force them to certify that. Use Mancea v. Mayflower, use the case law to say, I want to ensure that you've conducted that reasonable inquiry so you can get them on the hook later on.
Just the concern is that you all aren't aware either of what's going on.
Well,
obviously.
the bad actor problem, and we've always had bad actors, but the good things about having good process and having rules that we enforce and have disclosures and voluntary discussions is, the lawyers doing the ethical job, again, back to the ethics part of this whole program, is the ethics have to play, so the lawyers are doing the right things, so there's less and less space for the bad actors to be in, and eventually I've seen practically all bad actors do get caught. They just do, and it just might mean that you have to have more resources to find it, and maybe you actually work with the company, because again, the companies have an interest far and away from any individual, and that's where you have to separate yourself from the individual as a corporate lawyer, and then allow that investigation to take its path, and just like even the example in the BP Gulf situation, that engineer got convicted. Well, that engineer deleted text messages. Well, what happened to the company? The company had a legal hold. The company did the right thing, and the company wasn't shot for that. Might have been shot for some other stuff. Wasn't shot for that.
So one question I have for the panel, we haven't heard anything about discovery of website information. And the question is whether you've had any experience in, or what your view is on to what extent does a company have an obligation to retain the history of its website information. As we know, websites may change several times a day or several times a minute. Some information may be on the website that's damaging, but it may be up for only a few seconds or a few minutes. To what extent are companies expected to retain that kind of information so that discovery can be made of website information that was up 5-10 years ago?
No, I think it's a great question. It's that it depends law school answer. But that's where the due diligence comes in. So I've seen cases where, for instance, someone said the training video, you gave training to policyholders for an insurance company, right, about how to go on your roof and do things, and they wanted to see all the things about, what did you say last year, the year before, the year before? Were you giving bad advice and encouraging people to go out there for your own financial gain? Well, that made a lot of sense. That would be a fair game thing. So you look at the company, did they have a retention policy? How long do they keep their websites? Oftentimes they keep some historically, not everything. But when you have the litigation come in the door, it's a real consideration. We'll talk to the company, say, what do we have here that might be a public statement? Do we have to do something to save it? And oftentimes it's more complex than you think to try and save everything. There are third parties that crawl the websites and keep things, but I think the important takeaway to your question, which is a great question, is people have to think about this. And same thing with your Facebook sites if you're a company or an agency. The agency websites are fair game for all this stuff too. So it's an important thing to think about. It doesn't mean you have to be doing it all the time, but you should be thinking about it.
Question?
Yeah, I think the earlier lady who was trying to make a point about government lawyers, I think it's throwing the baby out the bathwater. Maybe she shouldn't use the word never, but I think it is difficult to hold government lawyers accountable because of the resources they have. And it's death by 1,000 cuts in a gray area. What are your comments about FOIA requests that come back 87% redacted? Because my experience is it's 87 to 90% redacted. What do you do in these situations where you feel like, excuse me, is that actually complying with the regulation? And now what am I supposed to do? Because I see that a lot.
Well, one thing is, of course, once you get into litigation, you can actually request a Vaughn index, which will actually force the agency to defend why it claims certain exemptions. But of course, the ability to get a Vaughn index only arises when you have the resources to bring a lawsuit against the agency, which a lot of FOIA requesters, you can imagine, don't.
Yeah, I think it's a tough question, because even when you get the Vaughn index, you're going to have 95% of it's all deliberative process, and then a bunch of other ones smattered around there, so you get very little. So I was fortunate to represent very significant large entities that wanted information from the government using FOIA. So we did. We fought it hammer and tongue, and of course the Vaughn index was lousy. So once you get there, you can get the information. Now, what should we really be saying? I think there's a movement today, and quite frankly, pay attention to this. NARA is trying to work with change the Federal Records Act, because the traditional rules don't work in the electronic age. I think there's a moment in time here that perhaps we can change the FOIA laws too, to take advantage of technology, make things more open so you get more information, and maybe we get out of saddling agencies with very expensive Vaughn indexes, which are very hard to do, like privilege logs. There's got to be a better way to do it to ensure a fair and open and transparent government, so we know what the heck's going on as citizens, okay? That we don't bankrupt the fiscal budget by requiring a paper world thrown onto electronic. So I would suggest that you really take a look and see if there's any way to get involved in the legislative side here with kind of revisions to the Federal Records Act that I think will positively impact FOIA for both the agencies and for the individuals.
I'll just add to that to say that a lot of agencies, particularly the past 2 to 4 years, have invested significantly in their eDiscovery programs. FOIA sometimes is leveraging those, not always, particularly though for the agencies who are involved in affirmative litigation. If you're dealing with an agency that has an affirmative litigation arm who has an eDiscovery program, if the FOIA agency, if they're not talking, it's very difficult for them to make the argument that we don't have resources, we don't have tools, we don't have technology. This is a reasonable search when you know that it really wasn't digital, it was manual. I think and there's actually a recent case I know that we had talked about previously, and I'm happy to look it up if anybody's interested, that talks about that. It's almost a waiver argument. How can the government really say that they don't have those resources when the division next door dealing with the litigation does? So I think if you're willing, if it's worth it in that particular case, to sort of get that, maybe it's backdoor discovery in your primary litigation matter, or you're just dealing simply with a FOIA request, I would say get to know the agency a little bit better. Ask for information about those policies and procedures, not just in the FOIA department, but in the litigation department. And if it's there, I think it's actually a really effective argument one can make as a litigant.
Any of the panelists, we have a couple of minutes if any of you have any final thing that we need to tie up. Otherwise, the luncheon and the debate are in the main hall. Let's thank our panel.
Yeah, you as well. Wow.
Thanks for keeping learning.